There we are. We're live again. We're back here discussing S7. It was a really good conversation with Josh Grimes from the Justice Center. But I wonder, Bryn, if we're in any position to start marking up the bill and going over with the idea of getting a bill out of here.
Can I just say,
am I missing something? Yeah, go ahead.
Well, I was just, Jeanette's objections made me wonder, when Jeanette, you seemed very sure that they had maybe mischaracterized Vermont's system. So I feel like maybe we should try to clear that up before.
What I would suggest about that is that we not put anything in there in S7 about that at all, but that we just deal with the expungement issue, and that we take up the whole, that whole issue around licensing after crossover. And it can be, and we can really look at the individual, the 97 instances where felonies are used against somebody, and we can look at those in more detail. I would not put anything in here about that. That's my suggestion.
Yeah, I thought Josh agreed to work with you.
Yeah.
On that, and it may be that the national group could be wrong, or it could be that we don't have a specific law, but it's in regulations.
Or it could be just the way it's worded.
Or it could be just the way it's worded. So I would suggest that we not deal with the issues regarding licensure, but that we look at, I think it's the one, the issues regarding expungement that he raised. But anyway, I think the easiest way is to continue through the markups. We haven't done any markup, have we, of this bill, Bryn?
Okay. Nope, you don't have a new draft yet. You've heard from witnesses about some requested changes.
Right.
I think that there may be additional testimony this afternoon about more requested changes. And I have a list of them, and I am working on a new draft. So once you make some decisions, I should be able to get you a new draft. The other thing I wanted to mention is that I know that you've heard from several witnesses about Section 6, which is the directive to the Sentencing Commission about looking into automated or some type of petitionless expungement process. And I think maybe you might be honing in on what you want to see there, especially since you now have the offered assistance of the Justice Center. So
right. That's at the back of the bill on.
Yep, that's page 20.
Section 6.
Last section.
Yeah. Okay. Let's start at the back. My wife always reads the newspaper from the back. So
I read mystery novels from the back.
That's
no, I don't.
I hope not. Anyway, so starting with Section 6, with Pepper, do you have suggestions here that would be in line with what the offer from Josh?
Can we put it on the screen? Is that possible?
Sure, I can.
What on the screen? Section 6?
Yeah.
Oh, okay. I'm sorry. I'm sorry.
You're a co-host, Bryn.
Okay, I just have to let me pull it up.
It's been a long day. I had a meeting starting at 8:30 this morning, Zooming. I don't know how I'm going to do it If I fall asleep during appropriations, you know.
I had yesterday, I figured out I had 11 hours of Zoom meetings with 2 half-hour breaks. That was it.
That's unbelievable.
It,
Well, just so you know, this committee is a great cure for insomnia.
you mean
You're
it a
ever up
lot?
at night and you can't figure, just come back on and watch one of these sessions.
I'm glad he's. Okay, go to page 20. Oh, we just had it up and then the screen dropped it. All right, page 20 is a study by the expungement or sealing listed crimes.
Okay, let's see if this works.
There you go. You're still on page 1.
Okay, but everyone can see that?
Yep.
Yep.
But you want to go to section 6, page 20.
I did, but do you not see that I did that?
No,
No.
we're still
No.
on page 1.
All right, hold on a minute. Let's try
but we
again.
all have hard copies of it, don't we?
Yeah.
They were
Well, I don't know
mailed
if-
to us.
I don't know if Alice does.
I don't.
They were mailed to us.
I just looked through my stack and didn't see
I
it.
don't know. The raccoon probably got it.
I can see it now. Can you guys see it?
Yeah, yeah.
Mhm.
You see page
Okay, well,
20?
it's up
Yep.
there now, Alice.
Yep.
All right, so it's a study. And how would you change this, Josh? I mean, Pepper.
Well, if you don't mind, so the Sentencing Commission created a subcommittee on expungement, and that's where a lot of the substance of this bill came from, but we've continued to meet. And Dave Scher is actually the chair of that subcommittee, and he might be willing to give you a brief update on where we stand. We met yesterday, and if he's still here, I know he had a
I think he
conflict.
had to go out to another meeting, so I don't believe. he's
I jumped back,
here. He
Senator.
is here. Oh, David, how are you? Good morning.
Good morning.
Would you state your name for the record, please?
Yes, David Chair, Assistant Attorney General with the Attorney General's Office, for the record.
You
And so
missed
I'll
an
give-
offer from the Justice Center. I don't know if you missed it, to help with this issue.
I did get the gist of it. I've been going back and forth a little bit here, but that is good news. I'll give the committee a brief update on some of the work we've been doing, which I will say up front, I do not believe, and I think the subcommittee would largely agree, we don't believe that anything should hold up the continuance of this bill, but did want to give the committee a little update. And what we've been working on is, as you know, this bill sort of embodies a compromise around access to records, and the fact of there's some differences between sealing and expungement, and the addition of or the change that to sealing that happened a couple years ago that allowed for broader access to sealed records by law enforcement, was the change that allowed for this much broader bill to move forward with the agreement of law enforcement, so that there'd be less concern around throwing some confidentiality over some of these more serious offenses. One of the concerns that, so this bill ended up being the sort of culmination of a bunch of those discussions where we're saying, all right, look, we are going to allow many more offenses to be, I'm trying to find a term that encompasses both sealing and expungement, but have increased confidentiality. And, those that are sealed, there's still a huge benefit to people who get offenses sealed in terms of the job market and being able to say that they don't have an offense. And expungement is protective and really fully puts people in the position of not having a prior conviction, because even law enforcement can't access those records. So this bill is the sort of culmination of that, and it embodies a two-step process for many offenses where sealing is available initially and then expungement is available later on. One of the concerns that Judge Grierson has spoken about in
Hey, John.
particular over the last couple of years is the fact that
Good, how's it
having
going?
oh,
Bill, you're muted. You're not muted, I should say.
So one of the issues is that having the two-step process potentially adds a significant burden.
Yeah, me too.
Thank you. Go ahead, David.
It adds a significant burden to everybody involved. The judiciary, the petitioners who need to petition twice, the prosecutors who need to do multiple hearings. And so one area that the subcommittee's really zeroed in on in the last few weeks is that second step where is there a way, now that we have a new system, now that there should be increased capability in the records keeping, is there a way to potentially make that second step a petitionless step, so that there's this initial step where people petition for and get sealing, and then the second step would be, I hesitate to use the word automatic, but would happen without a petition, and that would allow for a significantly reduced burden on the judiciary and the other players involved. I think there's actually a lot of agreement among the various stakeholders that makes sense.
I think he said that, yeah, Utah has a system that allows the state to oppose, even though there is no petition, or it's an automatic, but the state has the ability to oppose a particular case.
That's right. And I think that would, we haven't gotten into every detail here. My sense is that would remain as it is now, that the ability for the state to object would remain, although it would likely be the responsibility of the state to track that. But issues of notice and objection and things like that, we have not fully ironed out. I say all that to let the committee know where we're at. I think that, and to say that we are hoping to add that change in. I think a bigger change would be, and frankly, a more complicated change in terms of process would be a petitionless expungement from the outset. In other words, that first step, when you're initially asking for a sealing or expungement, whether that could be petitionless as well, has additional challenges, because you need to know when the sentence is completed.
But
and
Brindis needs to write something up so that we have section 6 the way you.
That's right. And I apologize for going on for too long. I think that I just want to let the committee know this is something we're working on. I think, and we can provide language that sort of summarizes what we're doing right now. And I do want to reiterate that we are, and I speak for myself, we are in favor of this bill continuing, and we will continue our work alongside it. And hopefully it's possible we could add something, before the end of this session that embodies some of what we're going to put in section 6, but we don't want to let our work impede the progress. So we can.
No, I think as long as there's a report back to the Justice Oversight Committee at some point, and that we have the language that you'd like in this section, I'm happy with that.
I think all we need is a sentence that says something like, the Vermont Sentencing Commission will report back regarding petitionless expungement or a petitionless sealing or expungement process. Something along those lines. Other members of the subcommittee can jump in and say if that embodies what we've been working on.
Senator Sears?
Yep.
David, I hadn't thought about this until Josh said the words moral turpitude this morning. In criminal law, we have the ability to attack a witness's credibility based on a prior bad act that may challenge their credibility as a witness if they've been convicted of a crime of moral turpitude. And I hadn't thought of this until just then, that we are essentially giving up that ability in the criminal law world by automatically excluding every single one of these from a criminal record. And I almost think there's a way for the individual to say they've never been convicted of such, even if one of the parties recognizes that they have been. And I don't know that anybody's thought of that before. I'm just thinking that perhaps if you're thinking about this going forward, that might be something to give consideration to.
Thank you, Senator. We'll add that to the mix in terms of how we think about these various definitions and access requirements.
Okay.
So this is Marshall Paul from the Defender General's office. I'll chime in just real briefly. I think that I don't know that there's quite the broad agreement that David says there is among the subcommittee for the proposal that David characterized. I don't think that's really relevant to Section 6. My suggestion for Section 6, and it's the same suggestion I made earlier, is simply to make it, instead of asking the Sentencing Commission whether a comprehensive policy that provides an avenue for expungement or sealing of all offenses will serve the interests of justice, because if that's what's asked of the Sentencing Commission, then the answer that is very likely to be received by the committee is there's disagreement as to whether a comprehensive policy that provides an avenue for expungement or sealing of all offenses will serve the interest of justice, and nothing further. So my suggestion would be that the direction to the Sentencing Commission be to develop a comprehensive policy that provides an avenue for expungement or sealing of all offenses. And then this committee can sort out whether or not it's actually in the interest of justice and whether it's good policy and whether, what changes should be made to it. And I say that mainly because the Sentencing Commission is a very large body with very diverse membership representing, the views from essentially every angle. And so the likelihood of ever getting any sort of a consensus view from the Sentencing Commission is pretty slim. That said, it's actually a very effective group for developing policy and legislation because it is a very diverse organization with everybody represented, and so there's every opportunity to put to make sure that everybody's voice is heard in developing legislation. So that's my suggestion, is just to simply direct the Sentencing Commission to come up with a policy and then let the legislature figure out whether it's in the interest of justice or not.
I'm fine with that. When we say all crimes, we're just talking listed crimes, are we not? We're not including the Big 12.
For the record, oh, sorry.
I think that's if you said all offenses, it would be all offenses, including listed crimes, including Big 12 crimes, and including drug trafficking offenses, unless you want something different.
I would exclude the Big 12.
If I might jump in, Senator, I think it's in the Sentencing, in fact, it is in the Sentencing Commission. There's another subcommittee that's working on revising all of the various lists of offenses we have, the Big 12, the listed offenses, the designated crimes. So, saying that we would exclude the Big 12 might be a moving target, depending on not actually clear what that subcommittee's been doing, and they aren't.
I just don't want to, I don't even want to, I'm not going to be part of any bill that would allow us to expunge those crimes. I'm not ready for that yet, personally. So I would be opposed to that. I would prefer at least the committee decide whether to add that in there or not. I don't mind looking at all the listed crimes. I don't mind looking at drug trafficking offenses, but I feel like we just got burned on the earned time policy, and I'd like to avoid that right now.
Sounds good.
So that's my take. for the purposes of, again, I understand, Marshall, for the purposes of continuing to look here. Okay, where do you want to go next?
Senator, I have one kind of substantive objection that I raised last time, but would like to just re-raise it.
Where are you? Okay, yeah, go ahead.
So this is James Pepper from the Department of State's Attorneys and Sheriffs. As you know, this bill expands sealing and expungement eligibility to a huge number of crimes, all but drug trafficking and listed offenses. And then it creates certain additional waiting periods for based on the severity of some of those offenses. You know, whether it's a predicate offense, there's a slightly longer waiting period. Whether it's a felony, there's a different waiting period. But then in each section, there's a provision that says that waiting period could be waived by the stipulation of the respondent. And then if you go back to the definition section, it says that the respondent could be either the state's attorney or the attorney general. And I think that that's a good policy in general, having this concurrent jurisdiction, because it's been working well. And there are some safeguards built in. But when authorizing the respondent to waive any waiting period to stipulate early, the state's attorneys really feel that should be the responsibility of the office that prosecuted the case, just for that narrow authority of waiving any of the waiting periods. And the state's attorney, the office that prosecuted the case, is really going to know the most facts about the individual offender. They're going to know the victim. They're going to know, they're more directly accountable to the communities where the crime occurred. And I think that it's important to leave that authority, whether or not to waive a waiting period for especially some of these felony cases, in the hands of the office that prosecuted the case. I've sent just, a real brief kind of sentence that would be added to this waiver provision, this waiving the waiting period. It would have to go, I think, 3 or 4 times in the various sections that authorize waiver of waiting periods. But I just wanted to renew that kind of that point, that concern that we have with this committee, so that it's not you're not caught off guard if you are willing to consider that and see the language, that you would kind of have some groundwork for why we're asking for that.
Okay. So it would read the prosecuting attorney or prosecuting.
I said, notwithstanding any other provision of law, when it comes to these early stipulations before the crime actually becomes eligible for either sealing or expungement, the respondent shall be the office that prosecuted the case. So, that language might not be perfect, but that's the concept is that, it would be the prosecutor who prosecuted the case that could waive that waiting period and expunge a crime prior to it becoming eligible.
David, any concern?
Thank you, Senator. And we spoke briefly about this a couple of days ago, I think, but for the record, I will renew the Attorney General's office objection to that and note that it is currently the case that the Attorney General's office has fully concurrent ability to stipulate to expungements, including expungements or sealings that waive the waiting period. That is currently the case, that the Attorney General's office has the power to waive that waiting period. Concurrent, with a jurisdiction that's fully concurrent to the state's attorneys, and we would ask that to remain. We spoke last time about the function that has in terms of allowing the Attorney General's office to help with large volumes of cases. The agreement we have with the Chittenden County State's Attorney, and that we have had with at least one other state's attorney at other times, and how that can be a very useful tool, and how it is our practice not to stipulate where we don't have any such agreement. And I'll note that, and as the person who reviews these, I do carefully note when a timeline is being waived. And there have been times when I say, even where there's an agreement with a state's attorney, I will say, look, this is a big waiver of a timeline, and I'm going to send this back to the state's attorney for their look, because they know this case, it happened relatively recently, and they should review it. So for all those reasons, I understand why the state's attorneys are asking for this, but we would renew our objection to this. Thank you.
Thank you. Alice Nitka,
Just wondering
Senator Nitka.
when there are disagreements as to each of those offices, where does it go from there if it can't be settled? I mean, probably wouldn't get there on this kind of situation, but where would it go if it can't be settled between the two offices?
I mean, we haven't had a case where there's been such a big disagreement that it's had to go to a court or something like that.
Is that where it would go, to court?
If one side objected and the other side wanted to stipulate, my sense is that there would be a hearing in court, and the court would determine what to do with that. And I think that this is a guess, but my guess is the court would treat the objection as the controlling state action, and then go from there. But I don't know that for sure. I think there'd have to be a hearing in terms of what would happen.
Okay, thanks.
Thank you. All right, well, it's exciting. We rarely have differences of opinion on these issues. How did we didn't deal with this in H 580 or whatever number bill was last year?
Nope.
Did we?
No.
Didn't deal with this. This is new. You know, you'd think it would be a simple little task to pass bills that we passed last year. You wouldn't think we had any. It's like opening up a can of worms. Can we talk a little bit about grossly negligent operation? It's on page 3, lines 14, 15, and 16. And it basically includes grossly negligent. Was there a disagreement there, or we already agreed on that?
So do you want me to share my screen again, Senator Nitka, so you can see that language?
Yes, please.
Okay.
I can't put my hand on. Thanks.
Do you see, is it on page 3 for you all?
Yes.
Yep.
Okay. So we talked about this briefly last time. This was, the change here was intended to correct a cross-reference, which was one of the recommendations or requests from the Sentencing Commission when they issued that report in 2019. And so what you see here is going to look different in your next draft. This subdivision B won't be struck through. So it will say negligent or grossly negligent operation resulting in serious bodily injury or death as defined in 23 VSA 1091B. And again, that limits the what's considered a listed crime to those careless or negligent operation that do result in serious bodily injury or death, and they don't encompass.
They're not expungible.
Right, so those would remain unexpungible, but it does not expand the definition of what is careless and negligent for purposes of listed crime statute.
Okay. And then,
So could I ask a question?
yep,
Because I've now gotten myself confused here. Are we saying that all listed crimes and qualifying crimes, qualifying felony property offenses are not eligible to be expunged?
no, and then you go to section 6, which asks for the Sentencing Commission currently that we just talked about, would look at that issue.
So why are we defining them here if we're asking the Sentencing Commission to look at them and come back to us and then give recommendations and then look at them? I guess I'm confused.
So the reason
Corrects an error.
That's right. This is hard to remember because the report came out so long, quite a while ago now. But one of the recommendations in the Sentencing Commission's report was to clean up a couple of cross references in the listed crimes statute. So that's why the listed crime statute appears in this bill.
Oh, it has nothing to do with expungement itself.
No.
Correct.
Oh,
For lack of a better term, it's a technical correction.
okay, okay. Sorry about that.
But I had forgotten that too, and thank you. So we go to section 2. The only, did we have changes there?
Yeah, so section 2 is the definition section in the expungement chapter. And this is sort of the big change. The big heft of the bill is in changing the definition of what a qualifying crime is for purposes of expungement and sealing. And oh, but do you mean any requested changes to this section?
Yeah,
Sorry.
yeah.
I believe that there is one, and the witnesses will correct me if I'm wrong, but the one request, as I understand it, is a technical correction to the definition of what a subsequent offense means, to clarify that a subsequent offense is the conviction of a crime committed by the same person who's seeking to have their record.
Expungement, okay.
So
So
just
now
adding a few words there on line 11.
On page 8, right?
Page 8, line 11, subsequent offense means the conviction of a crime committed by the person, etc.
Anybody with a problem with that?
Committed by the.
Now, remind me, these are in there because they do not qualify you for expungement?
So subsequent offense is defined here because we use it throughout section 3 because it changes the timelines for people to be able to access sealing or expungement if they have committed a subsequent offense.
But the qualifying felony property offenses, they are not they are exempted from expungement?
I think so that, yes, in the introduced version of the bill, I believe that felony property crimes are not eligible for expungement, but that was another request of one of the witnesses to make those eligible for expungement if the prosecutor stipulates to that.
So I guess my question again is, if the Sentencing Commission is looking at all of these, why are we listing them now instead of waiting for them to come back with a recommendation on how to deal with these?
So
Or do I misunderstand completely?
I think so. It may be helpful to talk a little bit more about that section 6. What I understand the committee wants to do with the directive to the Sentencing Commission is ask them for a proposal. And again, this is at the request of the Defender General's office. Ask them for a proposal to for expungement of all offenses. And it sounds like Senator Sears wants to exclude Big 12 offenses.
Yes.
So that would include what is not included in this as introduced version of S7, which is some listed crimes and drug trafficking offenses. So felony property, this S7 would make felony property crimes eligible for expungement.
Right.
Oh,
What we're
That are
qualifying as
not
opposed to
currently
just-
eligible. It expands the crimes that are eligible for expungement,
Oh.
including felony property, which I think we had
Okay,
testimony last year about people who had those crimes and weren't able to expunge them.
okay. So it's qualifying as opposed to disqualifying.
Yeah.
Correct, right.
Yeah. If we go back to the hearing in Winooski.
Yeah, yeah. No, I was reading it backwards. Thank you. Sorry.
No problem. I'm glad you did that.
Bryn, was this also the section that roped in, we had witness Erica Reddick? Does she qualify under this provision? I can't see what the rest of the page says.
Which provision are you referring to, Senator
Um,
Ben?
Well, it would be probably the end of page 7.
Oh, this is the qualifying felony property offenses.
Right.
So
I'm trying to speed read here.
I don't recall that specific.
She had a charge of embezzlement.
Yeah, so it would,
It looks like it does qualify her.
And then she
Yes.
had
Line
subsequent,
15.
Line 15 has embezzlement.
There we go. Thank you.
This is Marshall Paul. Can I just chime in again?
Sure.
Ms. Reddick also had a separate problem, which was that her restitution order was ordered as a condition of probation, which is sort of an archaic thing. We don't do that anymore. And what that meant for her was that she was stuck in probation for much longer than she would have if she had not had that restitution order. So there had been brief discussion of, is there a way to address that situation for people who are in that situation where they, where restitution was a condition of probation, which meant that they were on probation for a super lengthy period of time. And I think my suggestion had been that there could be a couple of different ways to do it, but there could be either some sort of allowance in statute for there to be like a nunc-pro-tunc order that the court could issue that essentially took somebody off of probation kind of post hoc, so that the court could say, you really should have been off probation in, I don't know what, 2012 or something like that. And you would have been, had it not been that you had restitution as a condition of probation. That could then give them the ability to apply for expungement. Because the problem, I think, in her situation was that she wouldn't be eligible to apply for expungement until many years after she completed her sentence. And because restitution was ordered as a condition of probation, she didn't complete her sentence until very, very recently, even though the conviction is very, very old.
but I might be remembering wrong, but wasn't there also an issue with a subsequent offense where she lost her license?
I don't
Well,
remember that part.
I don't really think we should be going too deeply into one person's record to see if it's covered here.
No, I understand and I agree. I was just pointing out that in terms of Joe bringing her in for testimony, I thought the purpose there was to get us to look at the time period for the subsequent offense and what that allowed or didn't allow in terms of the request for expungement. Am I remembering that right, Joe?
I don't remember that portion of it. My distinct recollection was the main problem was that anybody that was put on a probation condition for restitution was essentially hamstrung, and we have yet taken restitution out of the violation category and have shifted it over into a civil way of addressing it. So I didn't want to see people who were on some kind of a payment plan subject to a restitution order still be stuck on probation for the purpose of trying to get off of this. It's a merry-go-round for trying to get them relief. But I don't remember the subsequent offense portion of it, Philip.
Okay.
Senator Sears,
Yes.
Chris Fenno, Vermont Center for Crime Victim Services. I just was talking to our restitution people about restitution, and they assured me that that piece about probation and owing restitution, it didn't prohibit that anymore. They're not seeing that. People are off of probation and we're continuing to collect money from them.
Hmm.
But it's not what they told me was it was not a barrier to getting off of probation anymore.
You're right, Chris. It's not a barrier to getting off probation, but we're trying to do here is make sure that this expungement statute aligns with that very concept, and I don't think it does yet. Simply because they're still paying restitution, they're considered to be on probation unless and until they get an order relieving them of that probationary status, they can't get an expungement. So I was hoping that there was going to be some conversation in here about trying to align their ability to get off probation. The mechanism for doing that doesn't stand in the way of getting them relief from expungement. I feel like I'm not articulating this correctly.
I don't know that I understood it correctly the first time or even this time, but what I would say is, you know, the center goes after restitution until it's paid. And, but the only sort of caveat for folks is that they actually have a court order telling them that they have to pay this. And if their record was expunged, it would mean that it would wipe out that requirement. And we would not be able to collect. And so that's what my concern is. But I don't think anymore that people have to stay on probation for an extended period of time. They can get off of probation, because we had this discussion about earn time, and that in fact people could continue to owe restitution even though they were off of probation.
Yeah, I don't see why you would say that you can't collect on a restitution order, even if they get an expungement, because there's still a restitution unit that's going after them for the money.
But there's no reason why they would have to pay it. We wouldn't have any standing to collect it anymore because there was no crime. And the restitution is part of the sentence. So if that is expunged, then there is no crime.
But there's still a restitution order in place.
But the restitution order is tied to the crime. It's tied, it's part of the sentence.
So you're saying that in your opinion, any restitution order should be a block to them being able to get an expungement if it's still not paid off.
Yes.
I don't think that's where we were headed.
The alternative is saying that it's just all going to be written off.
There has to be an alternative. I mean, if you're, I don't know what the alternative is, but there has to be an alternative to I have to pay it's a contract. I have to pay my credit card bill.
Mhm.
And it seems to me there's got to be a way of writing this as a contract outside of the crime itself.
But
If I could chime in
what I'm
again.
hearing is the problem is, what is the problem we're trying to correct?
Well,
I've lost sight of what the problem is, to tell you the truth.
okay. If a person has a restitution order in place, I hear Chris saying that the mere fact that it's in existence should prevent them from getting an expungement.
Mhm.
I didn't think that's where we were headed. Since the expungement unit was created, that's a whole separate collection mechanism outside of the scope of a criminal proceeding. So it may be that we have to simply make clear that an expungement someone of an expungement order. Because I don't want to see the victims end up without expungement, I'm sorry, without restitution being paid, but I also don't want to see that requirement as a bar to getting an expungement, if at all possible. And the only reason I'm saying we should be safe is that you have this restitution unit that is set up with a restitution order. That restitution order shouldn't disappear simply because we have an expungement that's in
But
the
I don't
works.
think, what Bryn has just posted, looking at line A, any restitution ordered by the court for any crime of which the person has been convicted has been paid in full.
Yeah, that has been a part of S7 since the beginning.
So are we talking about taking that out?
If I could chime in again, Senator, when it comes to the specific issue that Ms. Reddick was talking about, what's being discussed about whether or not restitution affects the ability to get an expungement doesn't affect her situation at all. Her problem was that because restitution was ordered as a condition of probation, the time that, like, when the clock
She
starts
couldn't get off
running,
probation until she paid out.
right? So the time for when the clock starts running for her was when her probation is paid in full, which meant that she could get, or when her restitution is paid in full, which meant that she could get off probation, and that started her clock towards expungement.
I see.
Whereas everybody else, it's as soon as their probation is over, that clock starts, and
So-
they have to have paid their restitution in order to get an expungement.
Yeah.
But they don't have to wait 5 years after they paid their restitution.
I see. So
Get an
that's the back there in the, where we say, in this case, at least 10 years have elapsed since the date at which the person satisfied the judgment for the conviction. The 10 years would be an extra waiting period because of the unusual circumstance of she and I'm assuming other people caught up in that, where they, part of a condition of probation was paying the restitution.
Yes, and I have no idea how many people are still on that, still have restitution as a condition of probation, or how
So
many people.
they can't get expunged until they paid the restitution. The question is, should that make them wait another 10 years from the date they finally paid the restitution?
Correct.
And if I might, Senator, on that point, David Chair.
Yep.
It's currently the case under, present law and as this proposal is constructed, that somebody could successfully get an expungement like the day after they pay restitution. It's a historical issue that there are some number of cases at this point. I don't know how many, as Marshall pointed out, I don't know if that's known historically, that the probation restitution are tied together. That's no longer the case. And going forward, you could wait that 10-year period after your probation's over, keep paying restitution through that 10-year period. And then
I would think that we could amend the bill by saying that anyone who is on probation simply for failure to pay restitution, as long as that restitution is paid, would be eligible.
Yeah, that would do it.
Somehow I put that in there. I don't know how to write it so that it isn't. So it's clear that the only reason they were still on probation was failure to pay restitution, or they hadn't been able to make the restitution payment. And that would be a sort of a grandfather clause or grandmother. Since we don't do that anymore. Is that okay?
That would work for me.
That would work for me too.
Draft something like that. All right. So are there any other things before we adjourn and take this up next week? Would Tuesday be soon enough? Bryn, are you available next Tuesday?
I think so. Let's check. Yes, I am.
Good. Why don't we plan to take this up next Tuesday and try to, if you can draft any amendments, and if people have amendments, if they could get them to Bryn and the committee so we could, I'd really like to get this bill out of here before crossover. All right. It's been interesting. And also in things that Josh raised. We have competition from Marley. Unfortunately, I might be able to hear that. So I think I don't know what his problem is, but since I have another Zoom meeting at noon time, I think we're gonna adjourn a little early and see you all tomorrow morning. We'll probably see you on